May 7, 2023. Unit 15 Landlord-Tenant Law, Assignment. Constructive Eviction, Costa-Hawkins Rental Housing Act, Demise, Ellis Act. Exculpatory Clauses, Habitability. Implied Warranty, Lease. Non-Disturbance Clause. Periodic Tenancy. Quiet Enjoyment. Rent Control. Retaliatory Evictions. Security Deposit, Sublease, Surrender. Tenancy as Sufferance. Tenancy at Will. Tenancy for years. 30-day notice. 3-day notice. Unlawful detainer action. Writ of possession, assignment, the transfer of one party's rights and obligations under a contract to another party. In real estate, an assignment may refer to the transfer of a lease or other agreement. Constructive eviction, a situation in which a tenant is effectively forced to leave a rental property due to the landlord's failure to provide habitable living conditions. Examples of constructive eviction may include persistent leaks, mold, or other health hazards, as well as serious disturbances caused by neighbors or others. Costa-Hawkins Rental Housing Act, a California law that limits the ability of local governments to enact rent control measures. The law prohibits rent control on single-family homes, condominiums, and newly constructed apartment buildings, among other things. Demise, the transfer of a leasehold interest in a property from one party to another. Demise may occur through assignment, subletting, or other means. Ellis Act, a California law that allows landlords to evict tenants in order to remove their rental properties from the rental market. Landlords must provide a certain amount of notice to tenants, and tenants may have certain rights to compensation or relocation assistance. Exculpatory clauses, provisions in a contract that attempt to limit or eliminate one party's liability for certain types of damages or losses. In real estate, exculpatory clauses may be included in lease agreements or other contracts, and are often subject to legal scrutiny to ensure that they are fair and reasonable. A-sense habitability, a legal concept that requires rental properties to be fit for human habitation, meaning they meet minimum standards of health, safety, and cleanliness. Landlords have an obligation to ensure habitability and make necessary repairs or improvements. I-sense implied warranty, an unwritten guarantee that a property or product is fit for its intended use and free from defects. In real estate, this means that the landlord or seller promises that the property is suitable for occupancy and that there are no hidden defects that would interfere with its use. I-sense lease, a legally binding contract between a landlord and tenant that outlines the terms of the rental agreement. The lease typically specifies the rent amount, the length of the rental period, and the rights and responsibilities of both parties. A-sense non-disturbance clause, a provision in a lease that protects a tenant's rights in the event of a foreclosure or sale of the property. The clause ensures that the tenant can remain in the lease space even if the property changes hands. I-sense periodic tenancy, a type of lease agreement that automatically renews at the end of each rental period, for example month to month or year to year. Either party can terminate the lease with proper notice. A-sense quiet enjoyment, a legal concept that guarantees a tenant's right to use and enjoy the leased property without interference from the landlord or anyone else. This means that the landlord cannot enter the property without notice or otherwise disrupt the tenant's peaceful enjoyment of the premises. A-sense rent control, a set of laws and regulations that limit the amount landlords can charge for rent and often restrict their ability to evict tenants, typically implemented by local or state governments in response to housing affordability issues. A-sense retaliatory evictions, an illegal practice by landlords in which they evict tenants in response to a complaint or action taken by the tenant, such as reporting a housing code violation or organizing a tenant union. I-sense security deposit, a sum of money paid by a tenant to a landlord at the beginning of a lease term, which the landlord holds as security against damage to the property or unpaid rent. A-sense sublease, a lease agreement in which a tenant rents out all or part of the property to another person for a period of time, while still remaining responsible for paying rent to the landlord. A-sense surrender, the act of a tenant voluntarily giving up possession of the property to the landlord, typically by mutual agreement or at the end of the lease term. A-sense tenancy at sufferance, a tenancy that occurs when a tenant remains in possession of a property after their lease term has expired without the landlord's consent, which can result in the landlord seeking to evict the tenant. A-sense tenancy at will, a type of tenancy where a tenant occupies a property with the consent of the owner, but without a lease or any specific term of tenancy. This type of tenancy can be terminated by either party at any time, with reasonable notice. A sense tenancy for years, a leasehold estate that is created for a definite period of time, such as 1 year or 5 years. Unlike a periodic tenancy, it does not automatically renew at the end of the term. A sense 30-day notice, a written notice provided by a landlord to a tenant informing them of the termination of a rental agreement or lease. It requires the tenant to vacate the premises within 30 days. I sense 3-day notice, a written notice provided by a landlord to a tenant informing them of a breach of lease or rental agreement. It typically requires the tenant to cure the breach or vacate the premises within 3 days. A sense unlawful detainer action, a legal proceeding initiated by a landlord to regain possession of a rental property when a tenant has failed to pay rent, breached the lease or rental agreement, or refused to vacate the property after receiving notice to do so. A writ of possession is a legal document issued by a court that authorizes a landlord or property owner to take back possession of their property from a tenant who has refused to vacate the premises, usually after the tenant has been evicted. The writ of possession gives the landlord or property owner the right to enlist the help of law enforcement to remove the tenant and their belongings from the property if necessary. It is typically the final step in the eviction process, after all other attempts to resolve the issue have failed. Types of tenancies. A leasehold interest, also known as a demise, is a non-freehold estate in real property. It is an interest where an owner gives the right to occupy or use property for a period of time. Tenancy for years. A tenancy for years, or estate for years, is a leasehold interest with a definite termination date. The tenancy does not renew itself, and no notice is required to end it. A tenancy for years could be a rental of a summer cabin for a weekend or a multi-year lease. Agricultural land in California cannot be leased for more than 51 years. Other property leases and mineral leases cannot exceed 99 years. Mineral leases differ from mineral rights, which are grants or reservations of a fee interest and can go on forever. Leases that provide for renewal options that could exceed statutory limits are unenforceable. Periodic tenancy. A periodic tenancy renews itself automatically from period to period unless notice of termination is given. Customarily, the period would be the rent-paying period, and the most common periodic tenancy is a month-to-month tenancy. Tenancy at will. A tenancy at will is held at the pleasure of the lessor for an unspecified period. Under a tenancy at will, there is possession without an agreement on the rent payment. If rent was paid or rent was agreed on, the tenancy would convert to a periodic tenancy. Tenancy at sufferance. In a tenancy at sufferance, the lessee is a holdover tenant. For example, one who retains possession beyond the expiration of a tenancy for years, or a home seller who fails to vacate by the agreed move-out date, is a holdover tenant. The lease. A lease is an agreement that transfers a right of exclusive possession for a stated term from a landlord, lessor, to a tenant, lessee. The lessor under the lease subordinates his rights of occupancy to the rights of the tenant. The lessor retains a reversionary interest. The lessor is entitled to possession when the tenancy has ended. Leasehold interests are considered personal property, chattels real, rather than real property. The laws of personal property, therefore, apply. Because a lease is a contract, all the requirements of a valid contract are required for a valid lease. Leases can be oral or written agreements. However, an oral lease is enforceable only if it can be fully performed within 1 year of being agreed on. To be recorded, a lease must be acknowledged by the lessor. Every residential property containing 16 or more units must have a resident manager. The maximum allowable security deposit for unfurnished units is 2 months' rent. For furnished units, it cannot exceed 3 months' rent. No later than 3 weeks, 21 days, after the tenant has vacated the premises, the landlord must furnish the tenant with an itemized written statement of the basis for, and the amount of, any security deposit retained, as well as the disposition of such security, and must return any remaining portion of such security. Evictions usually start with a 3-day notice to quit or cure, or to quit or pay rent. If the tenant fails to respond within 5 days, a default hearing is set, and the court can issue a writ of possession. After service of the writ on the tenant has 5 days to vacate, or the tenant can be evicted physically by the sheriff. A surrender terminates all further obligations under the lease. Surrender is the turning over of possession by the tenant with the understanding that all future obligations are cancelled. AF Unit Quiz 1. Which estate is of definite duration? A. An estate. It will be an estate for years. C. A freehold interest. D. A periodic tenancy. Answer will be an estate for years. Lease for a definite term. 2. A tenancy for years must be created by A. Express agreement. B. Adverse possession. C. Written agreement. D. None of these. Answer A. Express agreement. Because the term is definite, it must be by express agreement. 3. What is the maximum term for which a home in a rural area may be leased? A. 51 years. B. 99 years. C. 100 years. D. None of these. Answer B. 99 years. It is not agricultural land. 4. A tenant who remains in possession after giving notice that she would vacate the premises becomes A. A tenant at will. B. A tenant at sufferance. C. An indefeasible tenant. D. None of these. Answer B. A tenant at sufferance. 5. To be enforceable, a written lease must A. Describe the premises. B. Be signed by the lessor. C. Be both of these. D. Be neither of these. Answer C. Be both of these. 6. For a furnished apartment, the total security deposit may not exceed A. 1/2 month's rent. B. 1 month's rent. C. 2 months' rent. D. 3 months' rent. Answer D. 3 months' rent. 7. The landlord must return the security deposit to the residential tenant within what time frame after regaining possession if there is no damage other than normal wear and tear? A. 7 days. B. 3 weeks. C. 30 days. D. None of these. Answer B. 3 weeks. 8. Which statement is true regarding the assignment of a lease? A. The original lessee is the sole party liable for the payment of rent. B. It is the same as a sublease. C. The original lessee would retain a right to use the property for a limited time. D. The entire leasehold is transferred. Answer D. The entire leasehold is transferred. 9. A tenant on a long-term lease at $500 per month wishes to go out of business. The premises are currently worth $1,000 per month. You would likely advise the tenant to consider A. Surrendering the premises. B. Subleasing. C. Assigning the lease. D. Doing none of these. Answer B. Subleasing. 10. An assignee of a lessee has a relationship to the lessor of A. Sublessee. B. Tenant. C. Grantor. D. None of these. Answer B. Tenant. 11. A tenant on a long-term lease purchased the premises from the lessor. Later, to raise cash, he sold the property to an investor, who gave the tenant a 30-day notice to vacate. What are the rights of the parties? A. The lease preceded the sale, therefore, the tenant prevails. B. Occupancy was constructive notice to the investor of the lease. C. The purchase by the tenant ended the lease. D. Tenant rights were lost by accord and satisfaction. Answer C. The purchase by the tenant ended the lease. Lease terminated by merger. 12. In the absence of a lease provision, when would the landlord have the right of entry? A. During normal business hours after reasonable notice to show to a prospective buyer. B. In the event of an emergency. C. Either of these. D. Neither of these. Answer C. Either of these. 13. A landlord must ensure all of the following except A. That the premises are air conditioned. B. That the premises are clean and clear of pests at the time of rental. C. That the plumbing is in proper working order. D. That the roof does not leak and windows are not broken. Answer except A. That the premises are air conditioned. 14. Under a residential rental, the tenant must do all except A. Use the premises for a lawful purpose. B. Keep the plumbing in proper working order. C. Pay rent as agreed. D. Keep the portion of the premises under the tenant's control clean and sanitary. Answer except B. Keep the plumbing in proper working order. 15. Which statement accurately describes the liability of landlords of residential buildings? A. They are liable for injury only if they know of a dangerous situation and fail to act. B. They are not liable for any injury to a tenant if the lease has an exculpatory clause. C. They are liable only for risks that could be foreseen. D. They are liable for injury caused by a dangerous condition if they were negligent in acting or failed to act. Answer D. They are liable for injury caused by a dangerous condition if they were negligent in acting or failed to act. 16. The landlord was notified by the residential tenant that the water heater was inoperative and the roof had a bad leak. After reasonable notice, the tenant could A. Treat the landlord's failure to act as constructive eviction. B. Spend up to 1 month's rent and make the repairs. C. Do either of these. D. Do neither of these. Answer C. Do either of these. 17. When one residential tenant attacks another tenant, is the landlord liable? A. Yes, the landlord is strictly liable for the injury. B. Yes, if a check on the tenant's background would have shown aggressive behavior. C. Probably, if the attack was foreseeable. D. Yes, if the premises were represented as being safe. Answer C. Probably, if the attack was foreseeable. 18. A 3-day notice to quit or pay rent could be used against a tenant who A. Violated a lease provision. B. Was delinquent in rent. C. Used the premises for an illegal purpose. D. Did all of these. Answer B. Was delinquent in rent. Others would be quit or cure. 19. After a landlord has served an unlawful detainer action, the tenant A. is given 3 days to quit or pay rent. B. Has 5 days to answer the charges. C. Must vacate within 5 days. D. Must vacate within 30 days. Answer B. Has 5 days to answer the charges. 20. When a tenant abandons the premises with 3 years remaining on the lease, the landlord may not A. Sue for the balance due on the lease. B. Consider the abandonment a surrender. C. Re-rent the premises. D. Sue for the rent as it becomes due. Answer not A. Sue for the balance due on the lease. 21. Which of the following would constitute constructive eviction? A. Expiration of a tenancy for years. B. A notice to quit. C. An unlawful detainer action. D. The lessor's leasing the premises to a third party. Answer D. The lessor's leasing the premises to a third party. 22. A landlord cut off a tenant's electricity because the tenant was delinquent in rent. What would be the likely result of this action? A. The landlord could be subject to a $100 per day penalty. B. The landlord could be subject to a $1,000 penalty. C. No penalty will be assessed if a proper 3-day notice was served. D. There will be no penalty if there was a 24-hour notice of service cut off. Answer A. The landlord could be subject to a $100 per day penalty. 23. When a lessor and a lessee agree to terminate a lease 3 years before its termination date, the lessee's turning over possession to the lessor is known as A. Accord and satisfaction. B. Surrender. C. Reformation. D. Novation. Answer B. Surrender. 24. A tenant of a mobile home park may not be evicted because of A. Failure to comply with a reasonable park rule. B. Use that interferes with the quiet enjoyment of other tenants. C. Forming a tenant organization. D. Failure to comply with local or state laws. Answer C. Forming a tenant organization. Eviction is limited to specified reasons. 25. In a condominium conversion of an apartment building, the residents must be given an option to purchase their units for A. 90 days from issuance of the final public report. B. 30 days from the sale announcement. C. 180 days from public hearing. D. None of these. Answer A. 90 days from issuance of the final public report.